Hello, this is Matt on the Moon Lambo channel, and man, there's been a lot of news lately. Just yesterday, the Supreme Court ruled against the SEC in 2 separate cases. Also, the SEC got sued by Coinbase. You'll love to see it. So, not a really good day for Gary Gensler. For your old Gare Bear, not the best day. You maybe had some better days, maybe when you were younger, you know. Bad news again today for the SEC. From another Supreme Court ruling, which will impact the SEC. And that's a perspective from multiple attorneys within the crypto space. I'll share with you exactly what they're saying. But first, just let me say this at the outset of this video. You know, the XRP legal victory last July has helped pave the way to legal clarity for crypto in the United States. And also, since that crucial moment in time, courts, including the Supreme Court, have witnessed firsthand the tremendous overreach of the disgusting SEC, and the courts have quashed that overreach. I mean, they've been inching towards that case by case. And new developments, including from today, will make it even harder for the SEC to bring new bogus charges against any participant in the crypto ecosystem, including those in the XRP ecosystem. Now, don't forget, new bogus charges could, in theory, be brought against any participant, including Ripple, for any bogus reason. That's still a threat. Not the legal clarity of XRP. That's settled. But you could bring it for any number of reasons if you're the SEC. You can just make stuff up. You can make it. And so, the point is, though, all of the stunning legal defeats that we've seen with the SEC, including developments from today, make it way less likely the SEC will even attempt such a thing. This is one more thing that will result ultimately in more crypto entrepreneurialism in the United States. But we're going to break this down. But before going further, I do want to be clear. I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun, damn it. And if you don't like it, you can just get out. So to set the table here, you may recall this news from a little bit earlier in the month. This is from Blockworks. SEC drops investigation into Ethereum Studio Consensus. So let me just set the table here because there are some conspiracy-minded individuals out there. Let's put this nonsense to rest. There are no lizard people or shadow people masterfully playing out a script. These people in power, these are stupid people. Probably many of them narcissists and or sociopaths, frankly. They are not smarter than you. They're too stupid to be clever in the ways that you imagine they're clever and scripted. They're just doing whatever is in their best interest and whatever fills their ego and prevents their pride from being destroyed. That's what they're doing. They are not wizards. The SEC sent a Wells notice to Consensus, which of course is a document telling them that they were about to get sued. And the notice claimed that ETH itself was a security, among other things, of course. And, the political wind shifted. We've been talking about this a lot lately. It started in May. The political wind shifted going into an election season, though, and the tone against crypto from the White House softened, at least in the way they're paying lip service to all of us in crypto. Now, Kim Jong-Gensler undoubtedly got the message that the SEC needed to approve the spot ETH ETF. Again, election season, and so they did. They approved it after sending out the Wells notice, though. But they did so begrudgingly. And as a result of the SEC approving the spot ETH ETF, it was no longer tenable for the SEC to sue Consensus, for those reasons specifically. So they were publicly stating, they even publicly stated that they were dropping the investigation against ETH, because again, it was a Wells notice. The lawsuit hadn't actually been filed yet. It was going to happen, though, otherwise. But look, in their letter, which publicly declared this, they also made clear that Consensus was not exonerated and that, they were only dropping charges pertaining to this specific investigation. It never meant that future charges couldn't or wouldn't come. And I warned about that, too. And actually, who was most vocal about that was XRP community member and attorney Fred Rispoli. He, in multiple posts, has warned, hey, it doesn't mean that there can't be more lawsuits, and I agreed with him, and he was right, and I was right. And anybody else that said that was right. And so Consensus then By the way, so Consensus, they filed a lawsuit against the SEC proactively after they got the Wells notice, but before getting sued by the SEC, which ultimately didn't happen. But they decided to proactively sue the SEC. And Consensus then, publicly stated that they weren't going to drop the lawsuit against the SEC, even after the SEC stopped investigating them. So then now today, what happens? Now today, we find out the SEC is suing Consensus for different reasons. And they're clearly butthurt over this whole situation. Like they are really butthurt. Like Kim Jong-Ginsler wants to, continue attacking crypto in every single way the current administration will allow him to do, basically. And they wouldn't with the ETH, the ETH ETF, obviously. But does this sound like to you like these are incredibly clever people who are carefully scripting stuff? Or, based on the true story I just shared with you, does it sound like they're a bunch of bumbling dumbasses? These people don't know their left hand from their own butt. Like, I'm telling you, they did not script anything. They're different people with different motives. And they're just terrible people. Like, that's it. Nothing shadowy here. There's nothing reptilian going on. And so you get this headline: SEC sues Consensus over MetaMask's brokerage staking service. So I'm going to quickly cover this, and we'll get straight into the Supreme Court ruling, which is not good for the SEC, but definitely good for anybody in crypto. So check this out. The United States Securities and Exchange Commission has filed a lawsuit against Consensus, the parent company of MetaMask. So folks, if Consensus was untouchable, why is this happening? Again, different people have different motives. The White House versus Kim Jong-Ginsler over at the SEC, different motives. And Gary Gensler falls in line where he has to, but that's it. Other than that, he wants to keep attacking crypto because, he's a sociopath, big ass ego, and he doesn't like losing. It's embarrassing to him, and he's been losing a lot lately. Anyway, piece continues. According to a complaint on June 28th, the company has been operating as an unregistered broker and engaging in the unregistered offer and sale of securities through MetaMask swaps since 2020. The complaint claims that Consensus has collected more than $250 million in fees by brokering crypto asset transactions and offering staking services without proper registration, thereby depriving investors of crucial protections. The SEC seeks a permanent injunction, civil penalties, and other equitable relief against Consensus for these alleged violations of federal securities laws. So, my friends, if they were in cahoots to the degree that some have been stating is occurring, in conspiracy theory terms, this wouldn't be happening. No, wouldn't be happening. So the SEC gave up ground where they had to based on what the administration wants, and then they went forward with other stuff. Color me surprised, And so here, Attorney James Murphy, aka Meta Lawman, wrote, "Degenerate gamblers double down when they are on a losing streak." And he said that in reference to what's happening here. And then he shared this post. The SEC filed against Consensus today focuses on MetaMask staking and swaps. The complaint is a mirror image of the case Consensus filed against the SEC in Texas. In the complaint, the SEC declares these tokens are, quote, crypto asset securities, end quote, and then he lists CHZ, Luna, Matic, Mana, and Sand. We're going to come back to why that's not something the SEC can do in just a minute here, because with the Supreme Court ruling, from what I've gathered from multiple attorneys, that ain't gonna fly, which is great. So this is crushing the power that the SEC was asserting, even though it didn't technically ever have it. But that's kind of the point. It'll all make sense in just a minute here. But it's just kind of funny. So Consensus sued the SEC, and then and then the SEC looked at that, and they're just like, okay, whatever they're claiming we did, make it the opposite, and then apply the badness towards Consensus. Like that's like a child. These are terrible people. Like, come on, man. They don't believe what they're saying here. Fox Business journalist Eleanor Tarrant, as far as the Supreme Court ruling, shared the following, and this is interesting. She wrote, "Breaking. In a 6-3 opinion, the Supreme Court has just overruled the Chevron deference, a 1984 precedent that says when congressional laws are ambiguous, federal judges should defer to reasonable federal agency discretion." And so, folks, what that ultimately meant, that 1984 precedent that was set, means that, if there's not a law that specifically governs something, then let the bureaucrats, the unelected bureaucrats at whatever agency, just make up whatever the hell they want. And they call it within reason. Well, Would just say what the SEC's been doing has been reasonable? Obviously not. And then she writes, Chief Justice John Roberts said in his opinion, quote, courts must exercise their independent judgment in deciding whether an agency has acted within its statutory authority, as the APA, Administrative Procedures Act, requires. Courts need not, and under the APA may not, defer to an agency interpretation of the law simply because a statute is ambiguous. Bam! So Congress not giving the SEC power over crypto means they can't do stuff. There was this post also. So she wrote, what does this mean? The ruling curtails the power of federal agencies, taking away their power to interpret ambiguous laws through rulemaking. This is a big one for crypto and other industries that have been subject to unrestrained rulemaking from agencies like the SEC, giving more power to judges to interpret the law. So again, bad day for Gary Gensler, because he wants to be, he's Kim Jong-Gensler, supreme leader and dictator, unelected bureaucrat. He just wants to be able to do whatever he wants to do. Here's a post from attorney Jake Chervinsky, very well known in the world of crypto. And is he not with, oh, I didn't even realize he changed. I knew he was with Blockchain Association, but it looks like he's ex-Blockchain Association. Now he's chief legal officer at Variant Fund. Not familiar with him, not that it matters. Anyway, he's well known in crypto, and here's what he wrote. If you woke up this morning concerned about the power of the executive branch, here's some good news. The administrative state no longer gets to fill statutory gaps with political views that shift like sand from one president to another. At long last, Chevron deference is dead. And so again, the Chevron deference that is, again, courts basically ceding power to unelected bureaucrats if there isn't a specific law governing whatever topic is at hand. That's what Chevron deference is, and it's gone. It's dead now. Here's a post from Scott Melker, known as the Wolf of Wall Street. Chevron being overturned may be the biggest news for the crypto industry ever. To my understanding, this effectively means that the SEC's interpretation of the Howey test as to whether crypto assets are securities or not is irrelevant in court. Courts will now make their own determinations based on the law, potentially leading to different outcomes than those the SEC might expect under Chevron deference. And so there you go. He's saying, Howey not exactly applicable anymore. That is the SEC's interpreting, right? Which is why it's funny. And here's a separate post from Scott Melker. He's noting that the case I just highlighted, the consensus lawsuit, the new one here, where they cited several different cryptocurrencies as crypto asset securities. They cannot do that. But, it's the SEC and, the timing of it all. It's a little awkward for them. Here's a post from attorney John Deaton. Huge blow to Gary Gensler and Senator Elizabeth Warren's agenda of pushing the unconstitutional expansion of regulatory authority without congressional authorization. The final blow will come in November when I defeat Elizabeth Warren. Absolutely. And I'm sure the vast majority of you are aware, but in case you're new, Attorney John Deaton is running for Senate against Elizabeth Warren. And not surprisingly, Elizabeth Warren is very sad about this. She's a sad panda. She wants the Chevron death. Here's what she said. Let's call this Supreme Court ruling on Chevron what it is. A power grab by the far right to benefit the wealthy and well-connected. Look at how she spins this. Corporate interests want extremist judges to write the rules at the expense of consumers, workers, safety, and the environment. So that's right. This is bad. It's the wealthy and well-connected do us. No, this just means that unelected bureaucrats have less power. Idiot stick. What the hell does your problem be? So Attorney John Deaton saw that and reposted. So he reposted what I just shared with you from Senator Elizabeth Warren, who he's running against, and wrote the following. Right on cue, Senator Elizabeth Warren engages in gaslighting propaganda, attempting to make any decision she doesn't like about red versus blue or Republican versus Democrat. This decision by the Supreme Court simply requires elected members of Congress to do their job and enact legislation specifically authorizing a federal agency to do what it is attempting to do. I realize you hate the decision because it means U.S. senators will now have to become less partisan and work together and compromise instead of relying on partisan hacks like Gary Gensler to do the bidding for you. We do realize you much prefer to engage in name-calling, blame gaming, and finger-pointing politics. Senator Warren, let me remind you that your buddy Gary Gensler and the SEC hurt tens of thousands of retail investors and consumers by pursuing an unconstitutional expansion of the Howey test. I represented those retail investors pro bono, and Judge Torres, a lifelong Democrat appointed by President Obama, agreed with me. Not your buddy Gary. Who did the lifelong Democratic judge agree with? And he pointed down to a clip. So obviously hitting the nail on the head yet again, which will surprise nobody. He is correct. Here's a post from attorney James Murphy, aka Meta Lawman. He said, the Supreme Court of the United States ruling overturning Chevron reads as if written specifically with the SEC in mind. Money quotes right here. And this is from the ruling. Chevron thus allows agencies to change course even when Congress has given them no power to do so. By its sheer breadth, Chevron fosters unwarranted instability in the law, leaving those attempting to plan around agency action in an eternal fog of uncertainty. End quote. Well, does that sound like what's been happening in the world of crypto? There's this void of regulatory clarity, and then the SEC just makes up stuff? So, it's good news all around. You'll love to see it. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.